I was going to say, Mr. Bracken.
Thank you.
Good morning.
Good morning, Your Honors. I am Thomas Bracken, representing the appellants in this matter. The case involves the North Point Development Company's development of a 5 million square feet site in East Cambridge, which will consist of retail, commercial, and residential uses. This site was formerly used as a railroad yard. The Millers River ran through the site for many years and was subject to the tidal flow from the Boston Harbor. But the river and its banks have been filled in over the years, with the last license issued to the Boston Main Railroad in 1962 under a Chapter 91 license. The license was the final license that allowed the river to be filled solid. The license contains a specific condition that no structures unrelated to the railroad purpose may be placed on the fill without a further license. And this condition is similar to the provision that the legislature adopted in 1983 when it amended Section 18 of Chapter 91 to provide that all licensed filled tidelands required a license to either alter the fill or build or alter the structures. So today, the entire 48 acres is filled tidelands.
Yeah, it's theoretical only, though, that the public could ever use this property for fouling and fishing and so on. That just can't happen. It's all filled in.
Right, and it's not only theoretical, it's impossible.
Correct.
To fish, foul, swim, or hunt. But that, I believe, Your Honor, misses the point of what Commonwealth tidelands are, how they come about, and how they're to be treated even when they're filled in.
I take it, if I can, tell me if I'm wrong, but reduced to a nutshell, it is this property was filled in because there was a determination that it could be filled in to provide a use of the filled land which was a public purpose.
Correct, Your Honor.
And it is your view that therefore, in perpetuity, or until there's an appropriate proceeding, it has to be subject to some kind of public purpose. You can't just have the license granted in 1983, whatever it was, and then next time the owner wants to change the use of the property, any residual public use is simply out of the picture. Am I correct?
That's exactly correct, and that is the holding of this court going back to the Boston waterfront development.
So we can have wharves, and then we can have condominia, but the condominia have to provide some kind of public use. Am I correct?
Right, and that public use must be determined either by the legislature or by the department, but through a licensing procedure.
Correct.
And I think that Boston Harbor says, and we're talking about Commonwealth lands, which are the lands below the historic mean low water mark. The lower court found that 13 of the acres are Commonwealth tidelands, and that's supported by the affidavit of the appellant's expert, and he has a map, which is at the appendix, page 308, that clearly shows a hatched area, which are the Commonwealth tidelands. He shows the high water mark, the low water mark, the historic mean mark. So I would direct Your Honor's attention to that map. We go from the Boston waterfront development case to the case that Your Honor wrote the opinion, the Trio Algarvio case 3 years ago, where you said all tidelands below the high water mark are subject to this trust, that is the public rights trust, in the case of tidal flats, but in the case of submerged land, which are the Commonwealth tidelands, they can be transferred only by express legislative authorization. And then Your Honor cited the 1981 opinions of the justices, which clearly sets out the distinction between upland tidelands and Commonwealth tidelands, and specifically says that there are much more stringent protections for the Commonwealth tidelands than there are for the private tidelands that are above the low mean water mark.
Mr. Blackham, I correct with respect to those opinions, even if one were to concede, which you don't, that they suggest that the legislature had the authority to relinquish the public trust in tidelands and delegated its authority, the legislature didn't do that, correct? I mean, that's an advisory opinion. We get asked advisory opinions all the time, but am I correct the legislature didn't act?
The legislature specifically declined to pass bills that were before it in 1981 that would have relinquished public rights in tidelands that are not Commonwealth tidelands, but tidelands that are above the low water mark. And that's when they sought the opinion of the justices. And the justices says, yes, under certain conditions, you can relinquish rights if they are above low water mark. But below the low water mark, which is the Commonwealth tidelands, there must be an express legislative enactment, and they certainly didn't delegate any authority to the department to do exactly what the legislature refused to do itself, which was to exempt lands that are inland of roadways. So, notwithstanding what the legislature refused to do and what this court said were the rights, the department, we say, without any authority, no delegated authority, no authority at all, came up with this regulation that says any filled lands, whether they're Commonwealth tidelands, whether they're private lands, whatever they are, if they are separated from the flowing water by a roadway, then they don't have to get a license.
Well, by a roadway and by a sufficient distance.
Yes,
Distance
more than
means,
250 feet.
Yeah,
right.
sure. I mean, could I ask you, what is your response to the sort of pragmatic argument that is made by the other side that, you know, what do we do with the Back Bay?
That's very interesting, Your Honor, because there is a distinct difference between the Back Bay and the North Point lands. The Back Bay does not consist of Commonwealth tidelands. The Back Bay are tidal flats. They are above the low water mark, the mean low water mark. Therefore, if Your Honors decide in the appellant's favor,
well, maybe the Back Bay isn't the precise example. You know, when you look
Well,
at those,
that's the example they
when you
give.
look at those, you know, ancient maps of what this city used to look like,
yeah,
huge parts of it, the map is blue, it's wet, and now we know that is solid ground. Large parts of this city are like that. Can't DEP logically say we need to focus our attention on things that are close enough to current actual water, where access to the water, public use of the waterways would be affected, not to things that are distantly removed just because they once were water a very long time ago? What's unreasonable about that?
What's unreasonable is that the areas that you have in mind, which are not only the Back Bay, but other areas that have been filled in, and they have been built upon, and they have been built out. And so I would suggest it's a red herring to say, oh, yeah, this is the Pandora's box. If you decide for the plaintiffs here, there are going to be projects all over the place, Back Bay and everything else. Well, the difference is that those projects not only have been built out, but they are not on Commonwealth tidelands.
I take it as well, you know, one way to deal with that is, I mean, I just look at the legislative history here. It was very squarely presented to the legislature, and all I'm interested in is the legal question of whether or not the agency has the authority to promulgate this regulation. Because the regulation on its face doesn't seem to be, I mean, it's a policy decision. You can view it as reasonable or unreasonable. But I look at the history. The legislature asked for an opinion, got two opinions, and didn't act. And therefore, I mean, you know, and I'm looking straight at the agency, they can answer that question. It seems to me that that's a clear legislative choice. I don't know what you do in light of our case law about whether the legislature, that was an advisory opinion, can in fact change the law with respect to tidelands, but I don't seem to have that grant here.
Well, and I think that what is important here for tidelands that are Commonwealth tidelands is the public purpose, public benefits issue. What would happen in the real world if this project is subject to licensing would be that the department would have to ensure that the land continues to serve a public purpose and that it will provide public benefits. And as we said in our briefs, the public benefits are illusory here. To move the T station from where it is now in East Cambridge and services all the people over there and move it across the McGrath or the O'Brien Highway and put it in this new development, yes, it'll be nice for the residents of their development, but it certainly won't be a benefit to the people of East Cambridge. The other thing was the park that was supposed to be a great benefit. And after all the briefing and everything, then the developer comes in and says, we have a wonderful plan for the park. We're going to build holding ponds and use these to contain the stormwater that runs off the buildings. So the park is rendered largely useless as a park area. So that's the real thing. The plaintiffs are not trying to stop the project. We know the project will go forward, and it'll be, pretty much as designed. But at this point, the parkland is still open. The Commonwealth tidelands have not been built upon. The storm drainage system has not been finalized. There are still action that can be taken that would provide a public benefit that would, for all of the people, as tidelands are supposed to provide under the doctrine that is as ancient as my memory, but before that, my memory is rather short these days. And of course, when you say that, Judge Sussman, that the department should be able to have some leeway here in what they review and don't review, well, they do, and they have in their regulations exempted minor projects, repair projects, maintenance projects. That's all laid out. We're not arguing with that. But we're not talking about a minor modification here. We're talking about a significant change in the use from railroads to what the developers call a new neighborhood, consisting of all of these buildings and including moving the transportation system into their project. They also come up with a rather esoteric argument, which is, well, the department is really not relinquishing any public rights in this land. They're just saying to the developer, you can go ahead and build on it, and then maybe in the future we'll decide to exercise the public's interest there. Well, of course, that's absurd. Once this project has been built out as a fait accompli, and no future review would be of any benefit to anyone. The other case, as I mentioned, Your Honor, in addition to Boston Waterfront, there's your decision in the Trio Algarvio case. Then the appeals court just a few, or maybe 6 months ago, came out with their decision in the Rousseau v. Commonwealth 65 Mass App Court 219, following your court decision in the Algarvio, and said, as you said, Your Honor, land below the historic low water mark is not like ordinary private land held in fee simple absolute, subject to development at the sole whim of the owner, but is impressed with a public trust. And so that is the point that I would like to make. It seems to me that whether you determine that only Commonwealth tide lands are protected here and not the rest of the project is immaterial, because as I say, nothing has been built in the Commonwealth tidelands, but those tidelands are pretty much coming down through the whole center of the project, so that the project will have to be rethought, clearly, to provide a public benefit in accordance with Your Honor's decisions. Unless there are any questions, I just urge you to reverse the decision of the lower court.
Thank you, Mr. Blacken. Mr. Ellickson? As I understand it, you have 9 minutes, Mr. Ellickson.
That's right, Your Honor. Thank you. And good morning. Benjamin Erickson, Assistant Attorney General for the Department of Environmental Protection. The question here about DEP's regulatory authority is one that has to be judged by the terms of Chapter 91 and not a free-floating concept about public trust. This exemption for landlocked tidelands from licensing is not a relinquishment of the public trust rights in this area. So we're not in the area where Boston Waterfront discusses relinquishment of public trust as having to evolve.
I understand that, but I think Mr. Blacken was trying to point that out. If in fact there's no relinquishment, but there's no requirement that the department satisfy the public benefit, which is impressed on these lands, isn't it a bit odd to say, well, we don't have it now, but we're not relinquishing it to sometime in the future? Because sometime in the future, I can just see a taking of property claim if we suddenly come in and say, well, actually, we let you build these buildings, but, we don't want them there anymore. You can't do that.
There are practical and legal responses to that issue. From a practical perspective, landlocked tidelands were landlocked before DEP issued its regulations and before DEP gets an application or a request for determination of applicability. These lands are at a distance from and physically separated from the water. They cannot be used practically to further the public's purposes.
Yeah.
Well, you may say that that's a conclusion, but you go back to the 1962 license. I don't know whether you think railroads are for a public purpose. Probably yes, right? But as I understand, am I wrong that the department has simply said we're exempting this because of the railroad, because of the highway and the 250 feet, so we don't have to go back and look at that issue? Isn't that what is before me? No?
No, Your Honor. They're saying that as of now, the landlocked tidelands do not contribute in any significant way to the purposes of Chapter 91.
Well, that's true, but can I ask you a more fundamental question?
Yes,
Where in the statute, Chapter 91, is there authority for them to adopt a regulation that exempts landlocked tidelands from getting a license?
Yes, there is, Your Honor. And
where is it?
That authorization is the broad authorization that the department has to fulfill the purposes of the regulations, fulfill the purposes of the statute by promulgating regulations, to fulfill the interests, to advance the interests of the public's rights in access to and use of the water in issuing any licenses, and a broad authority that it may issue licenses if necessary to advance those purposes. That's a broad delegation of authority.
What do you do with the 6th paragraph of Section 18? You're familiar with that paragraph?
Yes, Your Honor.
It says a public hearing shall be held in the affected city or town on any license application for non-water dependent uses of tidelands. Now, this is a non-water use, a non-water dependent use of a tideland, is it not?
That's right, Your Honor.
And it says you got to hold a hearing to get a license, and then they've got to see if the public purpose is outweighed by detriment and all that rigmarole. How can you get around that?
By reading the statute consistent with the purposes that it was.
How do I take into account that the legislature punted up to this court 2 questions? Can we do this? Yes, we said you can do it, and they didn't do it.
The questions addressed in the opinions of the justices were whether the legislature can relinquish the public trust rights as property rights in these lands. The answer
But if
was
there's
it
no-
may, but
But if there's no inquiry, if there's no license, I'm looking at the terms of the 1962 license. This license is granted upon the further express condition, those, the reason why we have a licensing procedure is to make sure that those public trust rights are being protected. At least that's one very important part. Then the department comes along and says, we're just going to exempt a whole lot of property because we determine, by the way, without looking at site-specific, we just determine in general. And it seems to me that what the department is saying, and correct me if I'm wrong, is once you've filled it in, the public trust which is impressed on Commonwealth title lands has to do with fishing and fowling. But once you fill it in, and because you can't fish and fowl any longer, the public trust is relinquished. That's in essence what the department's carve out of this this landlocked, filled-in land is in fact saying.
The Commonwealth disagrees, Your Honor. The reason is that the DEP could change the regulations tomorrow to require parts of this development or future developments here to respond to public purposes. But DEP, under Chapter 91, has that authority because the way Chapter 91 works is to give DEP this broad authority to create a licensing
But not to relinquish.
That's right, Your Honor. We don't dispute that. This is not a relinquishment.
But how are you going to get it back again in 50 years' time? Let's say that you've got, and I'm not suggesting that this developer's doing this. I haven't looked at the plans, but I've looked at the map, and let's say you've got high-rises, just like the high-rises across the street, that go from one end of the property to the other. Right? Absolutely. No public right, no public access, no public anything. I mean, how as a matter of fact, has the department not relinquished the public trust that's impressed on that land?
Well, the public, looking at it from the perspective of the public trust is a dynamic concept that could well change.
Railroads 1 year.
Railroads 1 year,
So you
condo
go and
development in other times.
You go and you get a license, and the department says, this is a public trust. By the way, there is a huge body of law in this Commonwealth that talks about whether or not benefits that inure solely to private parties, meet the public trust doctrine. But we don't even get to that if you don't have a licensing procedure.
The point on the question of whether it's practically relinquishing it is that the public trust, one, it's really preserving the status quo in the sense that these lands now do not serve the public's interest of access to the water.
But there was a licensing procedure that determined that this was an appropriate landfill, and presumably if somebody had thought that the license granted did not meet the legal requirements, that could have been appealed. And now somebody's coming to say we need another license, and the department says, sorry, you don't need a license because we've established a carve-out.
This exemption is the equivalent of a determination of the Department of Environmental Protection that public purposes, the public purposes that the DEP is supposed to protect under Chapter 91 are not implicated by a license. And so having a license for it creates a burdensome and absurd result.
I think you're trying to argue too broadly. Isn't that language in Section 18 really a limitation on the licensee, which of course is the Boston and Maine Railroad, which is no longer allowed, not a limitation on the department's authority to exempt a category of former tidelands such as this?
That's absolutely right.
Therefore, Section 18 doesn't apply.
That's absolutely
and for the same
right.
reason, more or less, the section I read to you previously doesn't apply either, and you win the case.
Right. I hadn't addressed the concept of these previous licenses, but the fact that there was a license in 1962 does not challenge DEP's authority to create an efficient regulatory system.
I know you keep saying that, and you keep talking about the broad language. I know you keep saying that, and I know you've got limited resources, and I know you want to focus on the fish and fowl, and that's just fine. But it seemed to me that what you really have is a kind of domino effect, and essentially what the legislature set up, consistent with all of the prior case law, was to say you can do it piecemeal by piecemeal by piecemeal by piecemeal.
Well, and to address that concern in a way that was discussed by the appellants here, the appellants, the DEP has to take into consideration the reality of licensing landlocked tidelands. The appellant's view is only supported through a reading that says the entire Back Bay, which is, by the way, both Commonwealth tidelands and flats, has to be rendered illegal. It's not the point. It's not the point that it was built once, it doesn't have to be again. Chapter 91 requires a license for every change in use and any additional structure, so that if the extension of the Boston Public Library is a structure that has to be licensed to Chapter 91.
I have to say, I don't find it helpful to go either way. Cases get brought when cases get brought, and I have to look at the statute and see whether or not the statute authorizes it. And as I say, I haven't yet heard a satisfactory answer to the legislature asking us a question. We send it back, and they don't act. I mean, generally speaking, that's a pretty powerful code, canon of statutory construction.
I don't think that it can be imputed to the legislature when enacting Chapter 91 what it was thinking when it previously had sent a different statute with different purposes to the court. A completely separate issue, the property rights in those interests, as opposed to licensing issues, which is a police power authority. And under police power authority, DEP is entitled to the normal discretion that it has to not have regulations which produce absurd and burdensome results. I see my time is up now. Unless there are any other questions.
Thank you, Mr. Ellickson. Mr. Sanders? And you have 6 minutes, Mr. Sanders.
Am I missing the point here? The opinions of the justices really have no effect on this case at all. And the provisions that we read previously from the 6th paragraph of Section 18, the 3rd paragraph, really don't apply at all either.
You are hitting the point on the head, Your Honor. The opinions of the justices, the justices in those cases were asked by the legislature to comment upon proposed authority by the legislature to irrevocably, forever extinguish or acknowledge the extinguishment of public trust rights, both landward of a line that was drawn by that proposed legislation and seaward. And the court, in commenting upon that legislation, discussed what steps the legislature would need to take to either itself extinguish those rights, acknowledge the extinguish of those rights irrevocably, or perhaps to delegate it to an agency.
Mr. Sanders, help me out of this.
Yes.
I mean, I do hear the department saying we're not relinquishing it irrevocably. But if you're not subjecting it to a licensing procedure, how does the Commonwealth, how do the people reassert their, quote, public trust rights?
They always have it for the exact same reasons that you yourself, Your Honor, wrote in the Trio opinion most recently.
But in this case,
you have the Commonwealth retains the privilege, and that's the word you used, to reassert those rights at any time. I'm representing the developer here. I'm saying I'm not asking for any relinquishment of public trust rights, which means I'm necessarily saying that if the Commonwealth wants to change its regulatory scheme 5 years from now and assert those public trust rights, we've got to figure out what those are, and then we have to deal with those.
Surely the more reasonable interpretation is it, because the question is all I'm trying to look at is how do we hold our government accountable in this sense? If they just say, we haven't relinquished them, we just haven't relinquished them. We can't show you how they've been asserted here because we've carved out a licensing scheme that says that you can bypass. I'm not talking about your client, but anybody who owns property that falls into this. And oh, by the way, the reason why we've done that is we really don't have enough resources, so we're going to focus on some other stuff over here. And nobody can challenge that.
The Commonwealth itself can always make the determination to itself assert those rights, those public trust rights again. Now, there are a different body of rights, separate rights that have been set up under Chapter 91, dealing with when do you need to get a license, when does the agency have the authority to exempt certain properties from licensure. That's actually a separate system, and we would agree with the agency that they've been given the authority to administer that system. They've been given broad authority, and within that broad authority it says they may license.
What does the term impressed with the public trust mean to you as a developer?
A property which is impressed with the public trust means that absent the specific steps that this Court said the legislature takes or delegates to an agency, absent those steps being taken, that property forevermore in perpetuity until those steps are taken is impressed with the public trust.
And what does that mean?
Now, what does that mean?
As a practical matter, what does that mean?
As a practical matter, it differs depending upon what land you're talking about. And, when this Court has discussed those cases in the past, right, you had to decide, well, how was this land created or reclaimed? Was this land former tidelands flats? The majority, by the way, of the land at North Point are tidelands flats which were lawfully filled. Then there are some formerly submerged land. That's a different category.
Correct.
So all those different categories, you understand, have different bodies of rights.
No,
so
of course.
what rights remain differs upon what those are. For example, this Court has said in opinions of the justices that landlocked tidelands that were either lawfully filled, as North Point's lands were, or formerly submerged lands that were lawfully filled, likely have no public trust rights. Now, we're not here arguing that that's actually the case. You don't have that record. But this Court has said that there likely are no such rights.
Not subject to 91 licensing requirements. Those lands were not subject to 91 licensing requirements. So now I have a 1982 license that addresses that head on. In other words, now I'm at the point in history where somebody is saying, I want to fill Commonwealth tidelands. And so you've now got a regulatory scheme that is doing that.
But if you follow my line of reasoning, all that's irrelevant because the earlier permit affects the B&M Railroad, not their authority to exempt.
That's right. That license and that condition license was a limit on the licensee, not a limit upon the agency to adopt a new regulatory scheme which didn't require that license once it became filled.
And I suppose your answer then to the sixth paragraph of Section 18, which says public hearing shall be held on a license application for non-water dependent use of tidelands, would be the same.
If you don't, that's a condition. If you need a license, that's the procedure you have to go through.
If you need a license, you've got to have a hearing, but if you don't need a license, you don't. And since you don't need it under the other section, nor do you need it to fill, because it's already been filled, that's the end of that.
That's correct.
Well, Mr. Sanders, you may have answered Justice Glaney. You haven't answered me when you say the Commonwealth hasn't relinquished.
No, theoretically, those rights are still there.
Let me give you two examples. I am not the Boston waterfront developer asking a court to register title, clear title, declare that there are no public trust rights here.
No,
I'm willing to proceed with those rights reserved. That's one example. I'm not the TRIO plaintiff coming in saying the department can't impose these occupation or displacement fees on me. I'm saying if those fees exist, if there are public trust rights like that exist, I'm going to develop them, subject to them, and And
I'm looking at the department that says, well, I'm not doing it permanently, but I'm just not going to do anything here at the moment. I'm not going to assert any public rights interests. I've just decided for this group these pieces of land, we're not going to do it. We may do it sometime in the future, but we're not going to do anything now.
I think it's very important that they have reserved them. And in fact, we believe that if they were to reassert them, we would not be in here arguing that they did not exist, but rather that our project met them nonetheless. My time is up.